Welcome to Week 4 of RGA 6217. This lecture covers ownership rights and intellectual property. Intellectual property pertains to any original creation of the human mind in areas such as science, literature, the arts, and manufacturing. Intellectual property rights refer to the legal rights given to the creator or inventor of the intellectual property, usually for a defined period of time, to allow them exclusive right to reap benefits from their creative efforts. These benefits may be commercial or recognition-based. In biomedical products, IP rights are absolutely essential given the enormous R&D investment required. Without IP protection, innovators could not recoup development costs, and innovation would slow dramatically. Understanding IP is fundamental to business development, product valuation, and competitive strategy. It is generally accepted that intellectual labor associated with innovation helps the public good and should be considered of importance to society. With R&D investment costs being so high in biomedical products, new technologies must be protected to ensure reward associated with the innovation and ensure continuous investment for future innovations. IP rights in the biomedical products industry help the economic condition of a country by spurring development, economic growth, and healthy populations through access to innovative treatments. Effective IP protection requires fair incentives for innovation, certainty for innovators regarding their rights, and strong enforcement tools for defending patents against infringement. For primary types of intellectual property serve different protection purposes in biomedical products. Patents are the most widely used form, attempting to capture the value of inventions, innovations, or discoveries through exclusive rights for a defined period. Trademarks are words, phrases, logos, or symbols that identify the source of products and distinguish them from competitors. Copyrights protect original works of authorship in defined media including literature, publications, and creative works. Trade secrets protect proprietary formulas, devices, or compilations of knowledge used in business that provide competitive advantage. Understanding each type and its appropriate application is essential for comprehensive IP strategy. A patent is an exclusive property right granted by governments to the inventor, for a defined period of time, which prohibits others from making, using, selling, and benefiting from the invention. The patent represents an exchange between the inventor and the public. The inventor provides full disclosure of the innovation for public benefit, and in return receives a patent or limited monopoly for use of the invention. Utility patents are most common in biomedical products, filed to protect how something is made, how it operates, or how a process improves how something is done. Design patents protect new and original designs, while plant patents cover newly invented and synthetically reproduced plants. General classifications of utility patents include composition of matter, which can be patented for all its uses both now and in the future, providing broad protection. Application or method of treatment patents target disease intervention through a new use of a compound or technology. Device or machine patents cover how a device is used to treat disease or how it is engineered. Each type has different scope implications for protection breadth and vulnerability to challenge. Patent strategy involves selecting the optimal type or combination of types to maximize protection while meeting patentability requirements. Understanding these distinctions is essential for effective IP strategy development. The USPTO applies several key criteria in determining patentability. The invention must be novel, not previously known or used. It must have utility, a valuable use. It must be unobvious to people knowledgeable in the field. The invention must be described adequately in the filing document. The description must enable a knowledgeable person to use the invention. Mode of action must be disclosed. Finally, the invention must be described in clear, unambiguous, and definite terms. Meeting all these requirements is essential for obtaining patent protection. Patent attorneys work to draft applications that satisfy each criterion while claiming the broadest possible scope. Certain categories of subject matter cannot be patented. Inventions that are not useful or that are offensive to public morality are excluded. Inventions that are not novel or are obvious cannot be patented. Living organisms that occur or exist in nature are not patentable. Naturally occurring is a key differentiator from engineered organisms that may be patentable. Physical phenomena discovered in nature are excluded. Ideas or inventions related to the arts cannot be patented but may be protected through copyright. Understanding these exclusions helps focus patent strategy on subject matter that qualifies for protection while pursuing alternative protection for excluded categories. Utility and plant patents provide 20 years of protection from the date the patent is granted, dependent on payment of maintenance fees. Design patents provide 15 years from grant date with no maintenance fees required. Extensions are possible through several mechanisms: remedying USPTO delays during patent application, remedying FDA delays due to regulatory approval, interim term extensions up to 1 year, and GATT extensions. Additionally, FDA can provide competition-free periods through market exclusivity that is separate from patent term, including new chemical entity exclusivity, new use exclusivity, orphan drug exclusivity, and pediatric exclusivity. Understanding both patent term and market exclusivity is essential for lifecycle planning. The Leahy-Smith America Invents Act, signed into law on September 16, 2011, represents the most significant change to U.S. patent law since 1952. Key changes include switching patent rights from a first-to-invent system to a first-inventor-to-file system, fundamentally changing who prevails when multiple parties claim the same invention. The law expanded the definition of prior art used in determining patentability, making it harder to obtain patents in some cases. The law also revised and expanded post-grant opposition procedures, creating new mechanisms to challenge patent validity. These changes significantly affect patent strategy, emphasizing the importance of early filing and thorough prior art searches. The patent filing process involves several important steps. First, confirm the novelty of the idea by searching USPTO and other sources to determine if prior art exists. File disclosure through your company, academic institution, or private lawyer before publishing anything that could create prior art. Confirm the business case through appropriate market research and due diligence. File a provisional patent to gain legal standing while allowing time for further commercial evaluation. Then file the non-provisional patent. Finally, manage the patent process by monitoring the filing, responding to USPTO questions, and paying appropriate fees. Each step requires coordination between scientific, legal, and business functions. Typical patent filings for biomedical products include several components. The face page includes all administrative facts including patent number, filing party name, key dates, and invention name. Claims specify what the invention is and what is being protected by patent law, including independent and dependent claims. This is the most critical section. Description adds necessary detail to the claims to determine patentability and scope. Drawings provide additional detail to substantiate claims and description. A provisional application serves as placeholder for 1 year, containing just a description of the invention. Care must be taken to ensure the description accurately supports the claims, as it cannot be changed when the non-provisional patent is submitted. The Patent Cooperation Treaty is an international treaty administered by the World Intellectual Property Organization, agreed to by over 125 participating countries. This treaty allows patent protection for an invention by filing one international application, which on approval is utilized in national applications to member countries. Advantages include reduced filing fees, reduced attorney fees, reduced translation fees, and reduce time to approval through streamlined processes. Due diligence must be taken to research member and non-member countries for appropriate protection in desired territories, as not all countries are PCT members. The PCT process provides an efficient pathway to international patent protection. A patent provides protection against someone else making, using, and selling the invention specified by the claims during the exclusivity period. Infringement takes place when someone other than the patent holder makes, uses, or sells the invention. Literal infringement occurs when exact claims of the patent are violated. Equivalent infringement occurs when a claim not literally infringed is still legally equivalent to what is claimed, a gray area depending on case context and judicial perspective. Sanctions for infringement include injunctions requiring the infringing party to cease activity and monetary damages. Willful infringement can result in treble damages and attorney fees. Demonstrating good faith can mitigate damages. A trademark is any word, phrase, logo, symbol, or other device affixed to a product that allows consumers to identify the source of that product and distinguishes it from competitors. A service mark is similar but identifies a proprietary service rather than a product. Trademark infringement occurs when there is great likelihood of confusion in the market between an established mark and a competitor's mark, to the detriment of the innovator company. While trademarks don't require registration to have legal claim, registration provides important benefits including establishing ownership and usage, better legal protection for infringement actions, and ability to license the trademark. In biomedical products, significant effort is devoted to selecting and protecting trademarks. Trade secrets could be any formula, device, or compilation of information and knowledge used in business that provides an opportunity to obtain advantage over competition. Trade secret rights have indefinite lifespan as long as they are not terminated by public disclosure, unlike patents which expire after their term. The importance of trade secret laws has grown due to highly competitive markets and rapid technological change in biomedical products. To establish a trade secret, the information must be protected as a trade secret, not be common knowledge in the industry, have reasonable precautions taken to maintain secrecy, have some value attached, and have some definiteness or substance. Trade secrets offer an alternative to patents when perpetual protection is possible. Academia, government, and research institutes continue to invent and develop breakthrough technologies, especially in biomedical products. Industry usually works with these non-profit organizations to gain access to know-how and create commercial products in for-profit businesses. In the transfer process, IP becomes a critical asset of value, sometimes remaining with the innovator institution, sometimes transferring to the acquiring company. Prior to 1980, significant government and academic R&D occurred with few efforts to harness IP value. The Bayh-Dole Act in 1980 allowed ownership transfer of IP from government to other entities including business, greatly increasing productivity in biomedical products development. This week examined ownership rights and intellectual property protection in biomedical products. IP protection is essential for biomedical innovation given the enormous R&D investment required. Different IP types serve different purposes: patents for inventions, trademarks for brand identity, copyrights for creative works, and trade secrets for proprietary know-how. Patent strategy requires careful planning from novelty confirmation through filing and maintenance. International protection through the Patent Cooperation Treaty streamlines global filings. Technology transfer enabled by Bayh-Dole has stimulated tremendous innovation. Understanding IP fundamentals is essential for business development, product valuation, and competitive strategy. Next week we examine the new product development process from discovery through commercialization.